your future with the 21.
Okay, today is the kickoff of the Above the Law, Evolve Law merger. My name is Elie Mystal. I am the executive editor of Above the Law. In a previous life, I was an associate at Debevoise and Plimpton, where I specialized in regulatory defense and complaining. It has served me well. I'm also the legal editor of More Perfect, which is a Radiolab podcast about the Supreme Court. Joe and I also do Above the Law's podcast called Thinking Like a Lawyer. So if you're all about media 2.0, if you've gotten to circa 2006, kind of hop onto the podcast. Above the Law is the largest website for the legal industry in the world, I believe. I don't speak Chinese, so don't check me on that, but we believe in the world. We reach 1.2 million unique visitors on the website, and about another 1.58 across our networks. That would include our website readers and Twitter and Facebook and email, our newsletter people. We Above the Law began writing about the legal industry in 2006. Our tech coverage back then was more like, law professors, are your students allowed to use laptops in class? Lawyers, are you spending too much time in your Crackberry? Wagtel, are you really editing Wikipedia pages at your desk? That was our stuff back in 2000.
Elie, I wrote an article about law professors not letting people use laptops last week. So,
right, so
I don't know if you want to...
Next sentence. 12 years later, in broad strokes, the debates are similar.
There we go.
We are still 12 years on talking about the same things. We're talking about what kind of things law students need to learn. We're talking about what technologies allow lawyers to practice more efficiently. And of course, we're talking about the ways that lawyers get into trouble when they don't understand the power of the technology at their fingertips. So while the debates have been saying that the technologies themselves have obviously changed quite significantly in the past 12 years since we started. In our everyday lives, we see the effects of technological change kind of obviously, right? If I say, oh my God, are you kidding me? Alexa's like, oh, we're about to fight our taxes again. We kind of get that at a home level. Legal technology has also advanced dramatically, but the legal practice has not at quite the same pace. Lawyers are naturally skeptical and risk averse. That's literally how lawyers are trained. That doesn't mean that all lawyers are Luddites. Lawyers like nice things. We're just a little bit slow to accept change. Our goal here at Above the Law and Evolve Law is to help our readers find technological solutions to make them better and more efficient lawyers. Because that's really, at the end of the day, all they're going to care about. Towards that end, we have added a vast array of columnists and partners to our stables. Many of them are in the room tonight. It's also why we've joined up with the Evolve Law community. In just 3 short years, Mary and Jules have built the largest community of legal tech startups in the world. They have 150 plus members, 30 plus events, 50 plus podcasts. Again, podcasts, it's kind of what happens now. We are excited to work with Evolve Law. Our goal is to strengthen our community with events, private Slack channels perhaps, public-private member directories and resources, and of course elevating the visibility of legal tech and innovation by embedding Evolve Law on the Above the Law website. We view this as a real opportunity to bring together lawyers and innovators, and at the very least we can all sit around and make fun of bankers and doctors. It's kind of like a pastime. Thank you again, everybody, for coming. Thank you to Wolters, Kluwer, and Integra Ledger for sponsoring us tonight. And let's get started with our show. Cool. So I want to start by introducing our panelists. First, we have Ginni Chen. She is the surge staffing specialist at Davis, Wright, and Tremaine's de Novo. Ginni focuses on developing and building flexible attorney teams to augment the innovative solutions that DWT de Novo offers to clients. Did I get most of that right? No. Not even a little bit? No. Okay. Sorry. Okay. Next is Dean Sonderegger. Close?
Yep. Yeah.
He writes for us, and we call him Blockchain Dean, so it's a little bit hard to... Dean is the Vice President and General Manager of Legal Markets at Wolters Kluwer. Dean's team provides technology and information solutions to law firms, corporate legal departments, law schools, governments, and other organizations. That's right.
Probably written by a marketing person, but yes.
500 is like what I go for. Finally, we have Joe Patrice. Patrice, he is a senior editor at Above the Law. Joe was a litigator at Cleary & Gottlieb and at Lenklers before he joined us at ATL. Joe actually has the distinction of being the ATL staff member with the most actual legal experience, which is a point that he doesn't really let people forget kind of on a daily basis, but there's that. He was an actual lawyer more so than any of us. So that's our panel. The format tonight is that we're going to have 4 innovators come up and talk about their products. They're going to do their Darwin talks about their challenges that they see facing the industry. They're going to go for 5 minutes. Then our panel will question them for 5 minutes, perhaps uncomfortably, perhaps funnily, we'll see. And we'll see if we can really get into their problems as they see it and how they think that we can be helped. Everybody has only 5 minutes, and I will be trying to hard stop people as we go. So with that, I think we should bring the first guy up. Our first person is Jonathan Broder, lawyer, founder, and CEO of VortexLegal, which provides on-demand lawyers for any courthouse nationwide. His talk is titled, "What Does Disruption Sound Like?"
Apparently the sound of 2 hands clapping.
So the title actually has been modified, but that's okay. It doesn't quite matter what the title is. Adoption. I heard a great statistic today from a guy from Thomson Reuters. He said that 60% of their clients are actually still doing leads format in 98, not even 2000 leads format. And so that should really set the tone as to, you can't hear me or I'm in the way? Sorry, is that better? Okay, so firms are still using Leads 98 or 98B, and some are using 2000, but Leads hasn't even been updated since 2000, right? And it's 2018. So we're talking, it's pretty self-evident even from the introductions that we had here that law is not good at adopting things, right? The technology, it's pretty self-evident. I'm going to tell you a little bit about my story with what I've done with my company and some of the challenges that we've had with adoption and some of the successes, frankly. So I started the company in 2010, but the truth is that I first had the idea, and by the way, what we do is we just have attorneys that attend hearings at other courthouses. So if you're a lawyer in Manhattan and you've got a hearing in Albany, our guy in Albany takes care of it. And actually, we have lawyers all day, every day at all of the courthouses here in the 5 boroughs. And so in 2007, I was a recruiter. And I went in at Robert Half Legal. I went into the CEO's office because it was right next to me. They're based in Miami. And I said, Chad, you know, I got this idea. We should have attorneys attend hearings as part of our temp staffing business. And he said, oh, that's a really good idea. To his credit, he was the nicest guy about it. You know, and that was amongst the many first times I heard no done very nicely. And he said, you know, basically get back and get to the core of what we do, which is, you know, recruiting. So I had the idea in 2007. And I didn't actually touch the idea again until 2010, by the time I was on my own. And what happened is I just said, hey, I've got this idea. I think it'll work. And I didn't know if it would work. But I had already been on my own doing a staffing business, and so I started to launch it, and I started to market it. And a couple of things happened. I was in Florida, which was good in some respects, because there was a real need for it with foreclosures. Okay, it works really well with that type of law. And so that my first order was in July of 2010, and yeah, July 2010. And right about September or October 2010, 3 law firms that were the biggest foreclosure law firms in Florida blew up overnight. And boom, out of business. Fannie Mae came in literally with guns to take lawsuit files out and bring them to other lawyers and law firms. And what happened is Fannie Mae went to all of these other firms in New York and Chicago and Georgia and said, come open up a firm in Florida. We'll give you 5,000 files to start. And they all said, great. But they didn't have an infrastructure to service the caseload throughout the state of Florida, right? These are flat rate cases, sometimes as low as $1,200. They don't reimburse for travel. You know, it's as simple as that. And so I had the idea in 2007, didn't realize it and materialize it until 2010. And then all of these crazy things had to happen before this business really started to take off. And I think that that's really one of the things that we all need to remember about adoption, is that it takes time, right? Your timing has to be right. And then not only do you have to be a little bit lucky, but there's all these different circumstances that have to, you know, develop so that it works. And for me, and for what we did, it really was the flat rates, the no travel, the portfolio approach. And those are things that are slowly, this was 2010 still, so those are things and concepts that are now percolating into the rest of the legal industry. You're seeing a lot more AFAs, a lot more portfolio management. Companies are not reimbursing for travel. You know, they'll pay you for 50% of your travel, but certainly not 100% for your billable hour. So I think we're at a really unique stage and a really unique time where the business needs and the business is really driving, that it's forcing innovation, and it's creating an opportunity for, you know, all of us that are in this space. I think that there's also so much happening right now that's awesome, right? You've got Evolve Law, you've got Clock, you've got Buying Legal, ACC Legal Ops. These things were not around back then. And I guess the reason that I have the ALSP up here on the screen is that for years we didn't really know how to describe or identify ourselves. And it was only about 2 years ago where all of a sudden it was like, oh, yeah, we're an alternative legal service provider, duh. But it really wasn't a term that people knew about. And so, you know, it's really about all of us in the community getting to know what is the ALSAP, what are the things that are out there. And I'm seeing that I've got 1 minute? Time. So thank you for your time. And if you don't know what an ALSP is, get to know it, because somebody said to me yesterday, oh, it's the Association of Litigation and Support Professionals. And I said, that's the problem.
Jonathan, thank you.
There's a good place to stand. Oh,
Okay, panel, what did you think?
What'd you say, sorry?
What did you think?
Oh, that was great.
Thank you.
I would love to know more about who joins your network. Where do you find your talent? And where do you see that network of people, how do you see that changing? Or how have you seen it change in the past few years?
Well, yeah, I mean, we have over 7,000 lawyers that are registered in our network, a database of like over 1 million that we market to. And about,
speak up a little bit now.
Yep, so we've got about 7,000 attorneys in our database that are active, that are registered, and about 3,500 that are active and do business with us on a regular basis. And I was talking with somebody earlier about these numbers, because everyone wants to think, oh, well, that means something. And it does, but it only is part of the story. The rest of the story is, you know, I have a guy down here in Manhattan who, you know, he's one of the 2,500, but he's handling, you know, 80 matters a week for us. So the number of individual attorneys that we work with is just one piece of the equation. The rest of it is how much volume are they getting. Who are they? Solos, small, you know, firms, especially in the rural areas of the country. In New York, it's its own cottage industry. They literally only do this type of work. We require that everybody has 3 years of experience minimum. Obviously litigation experience. We vet them, we check their bar status, we do a background check, we interview them. We've got a very robust compliance program that we had to have, and we've had it in place for, you know, about 6 years when the default industry really became very regulated.
Hey, so great talk. Quick question for you. So we think about adoption and a life cycle of adoption from going from, you know, kind of your early innovators and eventually crossing over to the mainstream kind of market, even as a quirky and niche of a market as law is, right? So where would you characterize your service right now on that scale?
It's a great question, actually. So, you know, we really started in the foreclosure and default space, and we rode that wave up. And I said 2 years ago, well, what's going to happen, you know, for the next 2 years? Because fortunately, in the overall economy, you know, the foreclosure is not going to get us to where we want to be. And so about 2 years ago, we started to diversify into other verticals. And so we're working now with large corporations and really talking to them and saying, hey, look at your data, look at your billing codes. You're spending millions of dollars on these routine hearings. And literally, it's starting to percolate into mainstream. So we're getting there.
So you had a little bit of a pivot in terms of who your clients are and how you're selling that. Have you made any other changes to kind of the service offering as you've gone down the path, or has the offering stayed kind of core and who you're reaching out to has changed?
Yeah, I mean, it's really just been a change on who else needs our services and how do we get it into the more mainstream law or corporations. We really haven't changed the focus of this core service that we provide.
Excellent, thank you.
Congrats on finding the one litigation task I would want to do less than document review. But, but it strikes me, so obviously this makes a lot of sense in like the 2009 foreclosure market. But to some extent, technology moving forward as it is, how much of a lifespan does this have? Like at a certain point, I mean, the legal industry is slow, but at a certain point, we're going to have Skyped hearings. We're going to have, or whatever is better than Skype by 2 years from now. We're going to be able to have remote hearings. What is a physical presence going to be at that point?
The good news is that judges have egos, and they want you to come in and say, "Good morning, Your Honor. John Broder here on behalf of the plaintiff." I don't think that changes. You have remote hearings now. You have you can call in to a lot of jurisdictions. So the truth is, I don't see it having a huge impact on that. I could be wrong, but judges like to wear their robes. They want you there. And procedurally, I guess this is what I would add. Certain practice areas lend itself very well to what we do, right? Like foreclosure, collections, bankruptcy, and evictions. Then there's the jurisdictional aspect. New York is just hearing intensive. You know, and I don't know the exact number, but 45 days after a files complaint, you've got an initial hearing. 30 days after that, you've got another. So, you know, those things don't go away just because technology, you know, says so or
right, but
has an alternative.
But I want to pick up on something that Joe was, I think, getting at in a nicer way than I am, because I'm fundamentally an elitist. Like, I get how this is useful, like in Iowa. Like, Joe's, you're from like Oregon or Iowa, one of those.
Well,
they're right next to each other.
Yeah, it's one of those. Joe, you're from west of the Hudson, right? Okay, great. So I'm not from west of the Hudson, and I think that New York has when you talk about the hearing intensiveness of a big city, of a place like New York, of a place like Boston, part of the things that lawyers want to do is to go to those things, right? That's part of why they signed up for the job. So like, how do you penetrate a truly like urban environment, like the one that we're in, or?
New York's our biggest market, so it's abundant here. And I also say I'm from Nebraska, so I understand the urban, wherever that is. But you know, the truth is I totally lost my train of thought for a second. Hold on.
New York's your biggest market.
Right, New York's the thank you. You know, one of the things I say to clients, you know, law firms, they're like, I'm going to lose easy billables. And I'm like, well, yeah, but your clients are looking for value. They're looking for substantive work. They're not looking for easy billables. So they're going to cut you on that stuff anyway. And you should be focused on, you know, on billing stuff that's 100% collectible. You know, the other thing is if you're an associate, after you go to 5 hearings, you're like, it isn't that great. Okay, and in a lot of firms, they have challenges with their staffing issues and turnover. So I always say, this is a way, you know, millennials especially, they want substantive work. They want something meaningful. Honestly, going to these routine hearings is not meaningful, especially after the, you know, excitement of going for the first 2 or 3 times. So if it's a substantive hearing, guess what? We're not the right person to go use us. Anyway, you should be there on your own. But where it's appropriate, and there's plenty of them, this fits well. Even if you're in New York.
All right, Jonathan, thank you so much.
Thank you.
You know what, I'm just going to introduce from back here because the beer's here. Are people cool with that?
Yeah.
Okay, our second innovator is David Berger, Chief Technology Officer of Integra Ledger, purveyor of global legal blockchain.
Defending the use of blockchain in the law. Buffalo, 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 buffalo. That's a syntactically and grammatically correct sentence. We'll get back to that in a second. I'm David Berger, CTO of Integra Ledger. I live in Las Vegas, where what happens on the blockchain stays on the blockchain. So buffalo is an overloaded term, at least that's what programmers call it. It has multiple meanings and it depends on context. It can be a bison, a city in New York, or it has a lesser meaning to bully. So what does this have to do with blockchain? Well, blockchain is a really confusing term, and just like this, Buffalo, the sentence basically means there's some bisons in Buffalo that are mean to some other bisons in Buffalo that are mean. And I contend that discussing blockchain is about as complicated. By my count, blockchain is an overloaded term with at least four meanings. It's the name of a data structure, the name of an algorithm, the name of a suite of technologies, and an umbrella term for purely distributed peer-to-peer systems with a common application area. So let's disambiguate the term a little bit. I kind of think it's a blend of all of those, but I lean more toward it's an umbrella technology. So let's focus on the key aspects for law. It's a time-stamped, immutable ledger that can record digital data. It's secured by modern cryptography technology. It's distributed so that every computer or node has a copy of the data, and it's decentralized. There's no single point of control, so it's peer-to-peer. So if you think of it that way, my main argument defending blockchain runs this way. Most of the technology is not actually new. A lot of it's 30 years old, and a lot of it's already accepted in law. I'm going to give it the Generation Z test. My 9 and 14-year-old kids say, obviously, this makes sense. I'll actually give an example to back that up. And I'll admit that some parts of blockchain seem a little bit weird, the mining, the tokens. So I contend that to get blockchain accepted in law, the easiest thing to do is leave out the weird stuff, at least for now. So that's what we've done at Integra Ledger. So obviously, I'm a New York Jew. We do our Seder every year. And as a technologist, we like to download funny or bizarre Haggadahs, the Jewish text. If you look at the Humanist Haggadah, look up in the corner, there's something weird about it. If you do a search for God, it doesn't exist in the text at all. My point is that if you do the same thing with this talk, pretend I didn't bother mentioning blockchain at all, the topic would be using a mixture of existing accepted technologies and the cutting-edge variants for the use in law. Well, that's an easy one to defend. So here's an example. Take a Google spreadsheet. It's shared. Tack onto it the fact that you can only write to it. You have a blockchain. This is my speaker release for tonight. I hope it's legally binding. Digital signature, all of this is protected by asymmetric cryptography. Remember, I said that's one of the key aspects. Everyone accepts this. They're going to accept blockchain. The next thing is witness testimony. So a lot of law relies on witness testimony. And I think if I asked most of the audience, they would go, ooh, he made the handkerchief disappear. Well, watch the video. You'll kind of laugh about what I actually did. So I make the claim that... You won't hear so much because you're not talking into the mic. Okay, sorry about that. So here's the important point. I contend that if you took every frame of the video, hashed it, and recorded it on the Integra Ledger, you would have an incredibly good proof of existence that held up in court. So that's what the Integra Ledger does. So the big elephant in the room, my last point, how can I just drop off mining and tokens? If you're having a divorce, do you really want 10,000 hackers in North Korea deciding whether the data was legitimate? Not to be confused with the global legal hackathon, that we'll be hosting in February. My contention is that if you protect the data with the consortium of the top law firms and legal departments of Fortune 500s and top law schools, that you're in much better shape. That's the Integra ledger.
Thank you. Joe, why don't you start this time?
This is super useful, largely because, generally speaking, I think we all agree that blockchain's not worth the paper Bitcoin is printed on. But once you get out of cryptos, there's actually a ton of good uses of this. As you pointed out, people get, the cryptographic synchronicity, all that sort of stuff, smart contracts, whatever. The question I have is, are we seeing clients recognizing the value they can get from it? Because they drive a lot of tech change in law because lawyers are lazy and Luddites. Yeah, exactly.
Well, it's our opinion that the best way to get a law firm to change the way they behave is to have their clients request it. So the very fact that Microsoft made an announcement that they required fixed billing and not hourly billing will force, in my opinion, many of the law firms to become much more efficient. They have no choice. And I didn't discuss this detail. You can talk about it with us. The fundamental service that we have is not smart contracts. It's a universal system of giving IDs to everything from the lawyers and the firms to matters and the documents themselves and even revisions. So once you have a universal identity system, you can build upon that with really any technology.
Yeah, but let me push back on something you're saying and also push back on something that Joe's saying, because we have this fight internally all the time. The contention that this is all useful, as Joe declared this is useful, and your declaration that clients are going to want to be more efficient. Like, what evidence do we have that clients or lawyers actually care about efficiency? Joe, you're a frickin' notary. You've got a stamp. And there have been times in my life where I've had to literally go to you to get you to stamp something so I can buy my house. Like, we could have gotten rid of that with, as you pointed, I think, in one of your slides, we have the technology to get rid of the notary for decades, but we don't because nobody wants to. So, like, where's the impetus that we have to say that clients or lawyers are actually going to care about efficiency, like, in my lifetime?
Well, I have many responses, but one of them is everyone is talking here about doing the menial stuff as a lawyer is awful, and that you're scrambling to just find people. So if you could eliminate all of the tasks and use AI and blockchain and other technologies, then lawyers can move up and do more interesting things that AI and robots can't do. In terms of a use case, try taking 2 Excel spreadsheets and matching up the data without a good ID system, and you're going to spend hours doing something that could be done in a millisecond if you had Integra IDs on all of the records.
Right. You say spend hours, I say bill hours, but I get it. Dean.
So despite the moniker given to me before, it's not my first passion of blockchain, but nonetheless. So I think that when I look at blockchain technology right now, I think that you're absolutely right. It's the same term is used to describe a lot of things. So I think Cook County in Illinois did a whole study where they went through and looked at property records and conveyance of property records, and they kind of came back with the idea that pieces of the technology were very useful, but blockchain as it was implemented for Bitcoin, not at all what they would want to do in a public records kind of situation. I guess the question I have is, to what extent are you concerned that the hype around blockchain solving any and every kind of problem is going to result in a, for lack of a better term, blockchain winner, much the way we've seen with artificial intelligence a couple of times in the past 20 years?
Well, we're thinking of tokens and other things down the line, but we're waiting until we predict that there'll be an implosion at Bitcoin and Ethereum sometime soon. So part of my answer is we're going to sit back and wait And I've tasked my technology team to look very carefully at all of the alternatives. So whether something's going to win, whether it's even blockchain or not, some of the better technologies in blockchain 3.0, like R-Chain or Hashgraph, aren't even technically blockchains. They're using graph technology. So something's going to win, and at that point it may look nothing like the exact things I mentioned, but there's going to be more efficient shared data, and you need the feature that the data can't be changed once it's written so people can trust it. That's not going to go away. I don't care if it's called blockchain or something else at that point.
Sorry, we're at time, but how did you make the handkerchief disappear?
Magic.
He used the blockchain. That's cool. That was Elie. Are you paying attention? And we're all holding it, yeah.
Next up, Tom Martin. He is the founder and CEO of LawDroid, a bot automation company to promote justice. His talk is titled, Useful Bots Help Lawyers Clone Themselves.
Hi there. So I'm Tom Martin. I'm the founder of LawDroid. And there's going to be a lot of slides, so just note that in advance. So the lawyer's dilemma. Like all of us, there's only 24 hours in the day. There's not enough hours to get everything done. This is a time survey that shows that naturally we have about 8 hours to work in the day. It also showed that sleep, we've been getting more lately, but I doubt that. Clio did a study where over the 150,000 lawyers they have, they were noticing that there was 6 hours that were not billed or utilized at all by lawyers. When you break down that 6 hours, 48% of it, administrative tasks, 33% goes to business development. As most lawyers here know, getting new clients is a primary driver of work. Then this just came out at Legal Week, I think it was today, where we're showing that there is high volatility with law firms, and there's been revenue decline, revenue per lawyer decline, and so on. So there's a lot of downward pressure on pricing and the billable hour model. So I've been talking about the things that we have time to do. What about the things that we never get to do? So for example, this is an example where a lot of lawyers, they put that live chat widget on the bottom right-hand side of their website. They don't have time to actually talk to these potential new clients. So take this as a specific use case. Is there a chatbot solution to this? Well, a chatbot, it's a computer program that can automate tasks and conversation. So for example, what if you had a chatbot that popped up immediately when somebody visited your website, engaged them, greeted them, walked them through the services that you have, answered frequently asked questions so they could understand what kind of scope of work you do, told them about you, personalized you, humanized you as a lawyer. Megan here, she graduated Order of the Coif at 21, but she's also a Spartan racer and a mother of 4, so she could definitely fight for people that have California ethics problems. Then, if they're interested, they could book a consultation. And one thing that's really interesting that you could do with this technology is you could go through pre-qualification questions so that you could try to eliminate that 20% that you don't want to have as clients. It could also generate documents based on questions that are answered. Qualify potential new clients, triage legal issues, onboard new clients, schedule appointments are some of the applications. So some of the concerns that lawyers have are, do people want to talk to these things? I mean, are we getting ahead of ourselves? Do they really want to engage? Now, a consumer study by Ubicen showed that 68% of consumers, all they care about is the desired outcome. And that's what we care about. It's followed by ease of experience, speed, and that it's a convenient time for them. Now, the number one reason why they would talk to a chatbot versus a human being is the immediate responsiveness that they would get from a chatbot. So is the hype overblown? Of course it is with AI. You see ridiculous things like this, people worrying about this, and certainly this is not where we are, and hopefully ever, with AI that we're falling in love with it. So suffice it to say, don't make the perfect the enemy of the good. Chatbots right now, they're not perfect. They're not going to be human AI, but they do get the job done. This guy, what he says is, I hate the term AI. It makes people think we're building a single monolithic HAL. That's not what's happening. We're actually making washing machines. That's where we're at right now. But they're useful, right? Washing machines get things clean. So the major forces that are favoring technology adoption of chatbot technology are number one, efficiency, the downward market pressure on attorney pricing. Number two, consumer expectations of immediate engagement and a generational change. Number three, cheaper innovation is happening using technology right now. You can roll out on Amazon, utilize API.ai or Dialogflow with Google at a very low expense. And for lawyers, you keep your sanity, and you get to provide a better service to people that you want to have hire you. Thank you.
Dean, do you want to start this round off?
Sure. First of all, kudos on using Voltaire in any presentation. That's very good. Happy to see that. My classics background is not very strong at this point in time, but a quick question, though. To what extent do clients need to program these things themselves? My observation trying to sell things to law firms has been that the more energy that a firm has to put into creating something before it gets return on investment, the harder a pushback that I get. So is this something that they have to actually put and train themselves?
No. And I absolutely agree with that concern. For that reason, and being a lawyer myself for 20 years, I know exactly like how hard it could be to implement a new technology. So what we do is we eliminate that friction by getting scripts from lawyers, by getting their procedures, and any information that they have about what they currently do, and then information from their website, of course, and then put it together for them. We create a draft, we get feedback from them, and then we fill in the gaps that we didn't get before, and create a smooth conversational interface that matches their needs.
So I worked on a chatbot project once, and one of the things I'm curious about is how you get around all the security issues with either the client or with the law firm. Sorry. No.
Yeah, so of course security issues are a concern. And so it's a matter of using best practices, also having agreements with the lawyers in terms of what the scope of the privacy policy is, and whether or not we're actually functioning as an agent for purposes of gathering the information so that we're also under the attorney-client privilege or not. So those are legitimate concerns and things that we deal with specifically in our terms of service.
First of all, the HAL 9000 worked. It did everything it was programmed to do. For, you know, yeah, that's what it was told to do. Come on. But two, no, I've never understood the lack of understanding of why people want to do this. Like, I understand on the phone it's annoying because you hit a thing, you have to listen to a thing, whatever. But text, it's a reason why generationally people like to text more now than be on a phone. I've never understood why lawyers don't do that. Now, that said, I hate human interaction. So maybe that's just me. But do you think that there's, and I think you kind of hinted at it there, but there's a generational difference in like acceptance of this. Like that younger people might be more like, oh, of course I would want to talk to a bot to filter things. Or is everybody kind of equally into it?
So from the information I've seen, it's not equal. But it's not entirely generational either. I think it's too simple to say that, well, it's the 20-somethings or, you know, that are just using conversational interface. A lot of older people are using it as well. And you see it every day. I mean, you see people walking down the street, they're on their phones, they're on the subway, they're looking into their phone. So it's not also just about text, because conversational interface is also Alexa, Google Home, all of that. But the thing that binds it together is the conversation. And I really think that's the future because it allows you to essentially throw a blanket over a bunch of different services and serve them up through the conversational interface without having to deal with each and every single silo. So that's what's valuable about this.
Yeah, but one of the benefits of human interaction is that you know who to blame, right? So here, all right, so when I type in 5 O's here, what do? Right? And the chatbot tells me, open your door and say hello to the police officer. Like, who do I sue for ineffective assistance of counsel later? Because somebody should pay, like, right? Like, part of the issue is that how could you ever program the thing to give you that kind of real deep, good counselor advice that sometimes people need?
Well, like I said, it's about not making the perfect the enemy of the good. Okay, what we're trying to do here is automate simple tasks and gathering of information. And it's not to eliminate a lawyer, it's actually to augment them so they don't have to deal with those repetitive simple tasks. And so when that information is gathered, they're actually functioning from a point of knowledge and preparation so that they could deal with that client in an informed way.
How has your offering changed as you've gone through interacting with law firms?
Can you speak up a little bit? I didn't hear that.
I said, how has the offering changed as he's interacted with more law firms, or has it? Has it kind of stayed the same vision, or has it pivoted a little bit?
I think we've added on. I mean, initially it's this one where it's a potential new client-facing product where you're trying to capture money that you're losing because a lot of lawyers spend thousands of dollars to get people to come to their website and they bounce out because they're not having this. So it helps lawyers retain a lot more clients and make more money. Secondly, there's a back-end version of it that's more recent where for initial client intake, the simple questions and document gathering and all that kind of stuff, you could automate through the bot and then that way deal with the clients from an informed point of view.
Tom, if you don't mind, I got something from the audience.
Yeah, so I want to ask what exactly are advantages of this other than the sexiness factor over a search engine?
Well, I mean, a search engine would it would serve a completely different function. I mean, that would just be searching for information. I'm not sure I understand.
Well, like I think what you're trying to talk about is the level of conversation, right? The interaction that you can have back and forth with the chatbot. And I think what Money here is saying is that, well, don't you at some point get to a level of Google efficiency that you can you can find out everything you need to know before talking to a human just through a series of good searches?
So a chatbot, it's not meant as a substitute for search. Like, basically, it's not sitting there and just answering any open-ended question about anything. That's not its purpose. It leads people through a guided path of gathering information and gathering documentation. So it's more like what we actually experience as lawyers when we talk to clients. We have a guided path, a logic tree, and we drill down for further information. That's how we deal with them. We're not sitting there just answering any question under the sun. So it's completely apples and oranges.
And even in information, you know, as a content provider, I mean, we find clients that want to find things from a search, but sometimes you find a browse because I know the topic, and this is effectively a guided browse. I mean, you're going down, answer question, that informs my next inquiry to go down there. And that can be a much more efficient, if you don't know what you're looking for, that can be a much more efficient way of finding information than going down a search.
So basically persisting the context of a conversation, right? So you know, if I ask question A after asking a question C, that I may not get the same response as if I ask question A to begin with.
I think it's more like, all right, so last night I Googled, what the hell did I just hear? Because I literally heard something ridiculous, right? Now, I can Google that, and I have some ideas. So I'm like, was it a coyote? Like, what does a coyote sound like? What does a wolf sound like? What does the chupacabra sound like? Like, I'm putting those into Google, right? If I was working with a chatbot, when I was like, what did I hear? That I could literally just say to the chatbot, what did I just hear? And the chatbot would say, arguably, where do you live? Or what time is it? You know, and leading me into a point where it can answer that question for me. Is that a fair way of putting it?
Yeah. So I actually worked on Cortana at Microsoft some years ago. So one big challenge that we had was what we called context persistence. Good old days, you would ask it, who's the president of the United States? It would say Barack Obama. And then you would ask, how tall is he? Right? And it would know what that pronoun actually refers to. Right?
Right.
So you've implemented something similar, I'm assuming.
Yeah, I would say that this is, just to reiterate, it's about simple conversations gathering information. So it's not really holding a extended conversation about different things where it would have to hold too many variables in mind. But it does do that, and it does keep track of the different variables during the conversation and have a session that it maintains.
Thank you, Tom.
Thank you.
Our final innovator is Michael Simon. He is the principal at Seventh Samurai, an e-discovery firm. Mike doesn't make products. Mike helps others make and market them better. Mike, are you up there?
Hi, everybody. Mike Simon. Leading law professor in analytics, Dan Katz, likes to show this graph about the trouble we're facing in the legal profession. We're facing a problem with automation, and many lawyers are in danger of being replaced. He says that we should turn many lawyers into legal technologists. That's a great idea, but it doesn't save everybody, because we've got a problem with lawyers potentially being replaced by robots. Now, when we talk about the legal future, we tend to fall into one of two camps. We're going to have an AI-assisted nirvana where technology does all the hard work, or a jobless robot hellscape. In the end, though, the answers are really going to have both. It depends on where you sit. Now, some great authors with me from Hogan Lovells, we cover this in an article that's coming out soon for the Yale Jolt, and we talk about our potential legal future. But the key that we really start with is to pull back the curtain on a case that hasn't gotten enough coverage. Happened a few years ago, Lola versus Skadden. The court was asked to rule what is the practice of law in the face of impending AI and mechanics. And what they said is, essentially, you could read this, you could read the whole opinion, but I'll give you the quick download. Robots can't be lawyers. But at the same time, they left something open. The flip side of this equation, that if robots can do it, it can't be lawyering. And that lets robots replace lawyers as they get better. Now, to push back against this, some experts say we need to expand what we do as lawyers. Let's become T-shaped lawyers. Let's add technology and analytics. Or maybe we should become plus-shaped lawyers and add some other stuff. Well, that's great. And in fact, we've got leading law professors telling us we should learn to code. We've also told this by leading lawyers. And leading sexy murder bots tell us this too. But you know, there's some issues here. We need to break through and shatter the idea that coding is easy. It's not. People who learn to code and people who are good at coding, they start early and they put a lot of work into it, and it's not easy. But more importantly, the people who are building these systems, like at Microsoft, tell us what they want is not lawyer coders, but lawyers. They want our ethics-based skills. They want us to use those skills. So perhaps instead of being T-shaped lawyers or plus-shaped lawyers, what we really need are lawyer-shaped lawyers. We need to be better at what we do so we can work with them. And what we found is we looked at a lot of different ways to cope with this new world. And the best that we found, one of the few positive ones we found, was this book by a couple people who've been studying this for years. And they proposed 7 ways that we can still be relevant as professionals, as lawyers in this new future. And these are somewhat complicated. There's more to it. But I'd rather put it into 3 real simple terms: innovation, accountability, and judgment. Because that's what we're really about as lawyers. So innovation. The good news is we are seeing more and more firms innovate. There's still a lot more work to go. On Dan Linna, I made fun of him once on his tweet, so I got to put something good for him. He's done a legal innovation index. There are some firms that are doing great, others that are barely registering. But it's not just big firms. It's even folks like this woman from North Dakota who decided to build something. But here's the thing. And by the way, this is great. Money quote. I love that was put in the article. We're told money quote. She knows nothing about technology. She used her lawyer skills. She's a lawyer-shaped lawyer to work with technologists. And when we don't do that, we risk losing accountability. Study came out a few years ago, many of us know, I think Elie wrote on it, about how the leading sentencing software is horribly racist.
Yes.
It's terribly, terribly racist. But guess what? It gets worse. Not only is it racist, it's no more accurate than a bunch of guesses by random strangers. That's all. And so we don't want results in the law coming from random strangers or worse, mathematical bases. We need results coming from our judgment. I'm going to give Ralph Losey credit. He writes these huge articles, great stuff, but he talks about our need to help clients, to advise, to help them get to what they need. Because if we don't do that, and we just settle for mechanistic results, what we risk is throwing everything away. And that means we all get replaced. And that's a bad result. I'm standing in the light.
Yeah.
Where do I stand when I get grilled?
Yeah. It's a yes for me. No. No. I generally agree with all that. The importance.
No, you're supposed to disagree.
I know.
This is a terrible
I'm
grilling.
supposed to be the Simon, but occasionally Simon's the wrong side. So here I am.
Okay.
No. What I like about this is that I feel as though AI generally there's the people who say that it's this important thing that we have to work on, and the people who claim it's magic. And the importance of highlighting things like racial biases that can be built into it and mistakes that can be built into it and the lack of accountability is so huge. And I don't even know as though after that I have a question so much as a underlining. Like, don't give up on the idea that AI requires your help. You all have to be involved as ethical professionals in building it. So that was basically all I had. I had questions because I assumed this was going to go more AI is magic-y, but it didn't.
The two guys before me.
Yeah. So I'm like, no. That's kind of my stance.
I think program is easy, but that's
How many years have you been doing this?
30.
Okay, there you go.
But programming.
Did you learn with 2 classes in law school? No.
But programming being easy is kind of the point, though. You do things to make the program work. Like, it's the understanding that there is a human behind making it work right. And that's what I think some of the evangelists don't quite get.
So I'm a reformed programmer, just to lay out there in interest of disclosure. And I enjoyed programming a lot. I don't know that I would characterize it as easy for everybody, but I do think that we run into, anytime we walk outside of our swim lanes, we run into the danger of hubris, right? Stay in your lane. Yeah, we're not going to get into a LeVar Ball conversation. Please do not do that. But I do think, though, that, and I think that that's true also when you talk about data and analysis of data, and it's very dangerous if I have small sample sizes, for instance, to infer population. There is bias in data, all those things. But it can be extremely useful. And I think that when we look at AI from a provider to the law firm community, when I look at AI and the impact of it, I really look at it as starting to pull away things that are not value added. And so I think that when you look at, in contracts is a great example, right? Yep. The ways that I can write an indemnification clause to obfuscate what I'm trying to achieve in that, or any other clause, are not value added other than perhaps from a negotiation perspective. You're trying to come to terms between 2 parties. I would think that if you look at the technology coming down the pike, what it's going to do is it is going to change the way lawyers practice, but it doesn't change the need for the things that you talk about. And I think if you look at the accounting community, which is a little further down this path, I think what you saw is you saw no less demand for services in accounting, but you've seen fewer providers. So I would like your comment on that. Do you see that occurring?
It comes down to this in a way, and I think. There's a guy out there, Ralph Baxter. He does these talks. He ran Oric for 23 years, turned it from a big regional firm into a worldwide powerhouse. Do you know what the one word, he's done it on video, he tells us we as lawyers need to stop using? Anybody want to guess? The one word, non-lawyer. What it means, and this is what I really want to see us do as a profession, we need to stop getting that Dilbert mentality. I don't understand what you do, so therefore it's not valuable because I'm a lawyer and I'm omnicompetent and I can do everything. We need to be working with folks. We are not going to make ourselves relevant by pretending we got all the answers. We're going to become relevant by working with people who understand the data. We need to know how we can work with them, but the first thing we have to do is to admit that we don't know everything, and we need people like programmers, or reformed programmers even.
We're always, what I do is I look for flexible teams of attorneys to sort of layer on top of technology and processes. And I'm curious if we think about how lawyers are no longer, or they're moving away from this, from traditional tracks where they stay at one firm and become partners, but they want mobility to go from project to project or from client to client. What skills could they get most easily now to be the perfect layer on top of this technology?
Don't take coding. Go to the clinic. Go work with actual clients who have actual problems. Go become a lawyer-shaped lawyer. I was a kid who did some coding. I'm not good at it. I'm not great at it. Maybe that's why I don't want lawyers to learn how to code, because I'm not that good at it. But more importantly, I went and actually became a lawyer. I spent almost 7 years practicing as a trial lawyer in Cook County, not on the real estate stuff, wasn't blockchaining anything. But I went in there and got kicked around for years. And I represented actual human beings who had actual problems that if I didn't help them solve it, if I didn't win for them, bad things were going to happen to them. Go deal with people who have problems to solve and get better at it. If you can't find that job, do it in the clinics. Do it pro bono. Do something to make yourself a better lawyer-shaped lawyer. If you can learn that appreciation for what those non-lawyers, people who do other things, the not 1 million people, the other 349 million in the United States, great. But be a better lawyer and learn what the problems are and start focusing how to solve them. And I do want to make one point. It's a terrible point, and this will be for the millennial types out there. We do need to be careful and not say that situations we're forcing the millennials in. Oh, the big firms are no longer hiring. Oh, you got to go do your own gig. Yeah, there's people who want to do that. But let's also be very clear that sometimes we're forcing them into that. And then saying, well, we know they love it. Let's do our best to try and build this into as much traditionally. So not only can they do this in a gig-based economy, but they can do this in an economy where they have salaries and benefits and know where they're working the next day. Just a little plea for the millennials, because I like them.
Can't think of a better way to end an Above the Law event than saying, be better, be goddamn better. That is our program for tonight. We'd like to thank Wolters Kluwer, Integra Ledger, again, for sponsoring us. We want to thank Mary. Mary couldn't be here because she's studying for the bar, so perhaps send her a text, because I hear people really like that right before the bar comes out.
Send her a text in the bar.
We want to thank all of our innovators, Jonathan, David, Tom, and Michael for speaking. We want to thank our panelists for coming. We have 3 events coming up this spring. One at Tech Show, which many of you have heard about. One at LegalZoom, and the Evolve Law Summit. I believe Tech Show is March 6th in Chicago. LegalZoom is April 11th in Louisiana. Wait, is it Louisiana or Los Angeles? Okay, well, technically, L.A.
Head south.
There's no periods here. There are no periods. Louisiana's a pretty fun place. Anyway, LegalZoom is in Los Angeles on April 11th. And the summit is the Evolve Law Summit is May 2nd in Chicago. Thank you all for coming. The bar is still open, so let's drink and hang out. Thank you very much.